Well, good morning, everybody, and thank you again for joining us, particularly and hello again to the ones that have joined me for previous webinars that we've done. I'm going to be covering the topic of Brexit this morning, all over the news every day at the moment, as we're all waiting in anticipation to hear what exactly is going to happen. I think one of the main things that we're looking at the moment is whether we're going to get a trade deal or not. I think lots of the HR staff will probably stay as is. So that's kind of the headline for the session this morning. Just having a look at my camera. Maybe I'll switch off my video so I don't distract myself. And double check. Okay, so you've already run through those slides, haven't you, Lisa? Thank you. So I've got two microphones. If anybody has a problem hearing, just put it on chat and I can switch to the other microphone. And if you do have any questions, as Lisa said, by all means, put those in chat and we'll pick them up at the end. So as of the 31st of January, the UK formally ceased its membership of the EU. We're currently what's known as in a period of transition, which will be the case until the 31st of December. As I said, this is to allow for trade and immigration arrangements to be reached, but there are interim immigration arrangements which I'll go through with you. And then there is a possibility that they may change, but it's my understanding is it's relatively unlikely that that will happen. So during the transition period, existing provisions around free movement of people remain as they were. From the 1st of January next year, however, businesses will need to have plans in place to support their workforce through the period of change. So we know that things are going to change in terms of how we recruit and retain staff from European countries after Brexit. We know that things will change around how we deploy staff who are based in the UK and work in European countries after Brexit. But this is about, are you contingency planning to consider how different these might look? Depends on whether we do get a deal or we don't get a deal with the EU. So we're going to cover the restrictions on the movement of people, looking at some skills profilings, an audit that you could undertake to try and look at how you might fill any potential gaps in the event of a deal or no deal, and have a look just a few key policies and procedures that you may need to review and update, and also just a reminder of consultation principles when you do that. And we're going to look at the opportunities that could be presented at this time, because as Brexit will bring lots of opportunities, it's just about looking at it almost through the right perspective and thinking about whether there's some opportunities that maybe you hadn't already thought of. So some of you may have attended other webinars around immigration. I'm not going to go into too much technical detail around it, but I'm going to go into a little bit of detail, just enough hopefully to give you a general understanding of the main things that you need to be thinking about if you haven't already. So as things stand, there are arrangements in place that will remain in place whether the UK makes a deal or doesn't make a deal for the movement of people. So there's still guidance. This is what we're getting used to expecting these days. Guidance still being developed to cover some areas that remain grey for some organisations. But what I'm going to cover is kind of what's generally accepted practice in the different forums and whatnot, then the different resources available that I can share with you. So essentially what we do know is that following the end of the Brexit transition period, so the end of this year, an overhaul of the immigration system will end the free movement for European citizens and bring the rules for EU workers in line with those governing non-EU citizens. They're going to be introducing job, salary and language requirements. So there is a Brexit transition tool. I'm sure most of you will have found that. It's on the gov.uk website /transition. And it's really useful because you can put in your individual circumstances as an employee or as an employer, and it will show you all the different things that you might need to think about in terms of your business type to help you to prepare, and even your family considerations. And if you've got plans to go to the EU. It covers lots and lots of different areas. It's really, really good. And then you can go and have a look at some more detailed resources, depending on which bits you need some extra guidance in. So we're going to have a look now at how will the end of the transition impact EU nationals currently working in the UK. So if you have EU nationals that work for you who are already resident in the UK, they'll be able to stay and have their rights protected after the end of transition and in the event of no deal, except those with major criminal convictions. Now, if the withdrawal agreement is ratified, then EU citizens resident in the UK before the end of the transition will have 6 months from that date to apply to the settlement scheme. Although, of course, most will probably have already been making their applications. In the event of no deal, then EU citizens resident by the 30th of March 2019 will have until this year, until the 31st of December to apply for the scheme. So that's why most people will already have applied, because if there isn't a deal, then there is a possibility they're not going to be able to apply for settlement status. So if you do have employees who work for you, then what you need to be doing what you can without asking them specifically to encourage them to apply to the settlement scheme. And frontier workers, I'm going to cover them a little bit more in a little bit of detail later. They'll also be able to continue to travel from one member state, such as Ireland or France, to the UK daily for work. So how will the end of the transition impact UK nationals currently working in the EU? Well, each EU member state has actually established different processes, unhelpfully, for UK citizens to register to stay after a no-deal scenario. They do mostly reciprocate the UK's offer to EU citizens, but some have only provided this on a temporary basis, like Denmark, for example. Some don't address either a continuity for professional qualifications that individuals might possess. So at the moment, there is a reciprocal agreement with it across the EU to recognise professional qualifications across all of the countries, and that is very likely to change. And anybody who works with who has workers from non-EU countries will know there's different exercises you need to undertake if you're bringing people in and you want to recognise their professional qualifications in the UK. There's an assessment process that you can go through in order to do that. So the impact on UK nationals working in the EU in the event of a deal would depend actually on the outcome of the negotiations. So we don't at the moment know exactly what that looks like. Although, as I said, there are different processes that have been put in place in the different countries in the interim. But if we don't get a deal, then those may change. In fact, if we do get a deal, they may also change. So how will the end of the transition impact you hiring EU nationals in the UK? Because that's the one that most people want to understand. So they'll continue to be able to travel to the UK and take up employment on exactly the same basis as now, up until the 31st of December this year. EU citizens, as I said, who've arrived between the 30th of March 2019 and the 31st December 2020 will be able to apply for European temporary leave to remain immigration status. So this is a 36-month temporary immigration status, after which they'll need to apply to the new immigration system, which is going to come into operation from 2021. So the EU settlement scheme that I mentioned already, you need to be aware, if you're not already, that the new system won't apply to EU employees already working for businesses in the UK. So EU citizens and their family members living in the UK by the 31st December can apply for the scheme up until the 30th of June 2021. To retain existing staff, then you need to remind, as I already said, your EU members of staff to apply under the settlement scheme to secure their futures post-Brexit. You might also, which lots of organisations are doing, want to consider hiring staff that you possibly won't need until early next year now, but so that they can rely on the free travel area now before it's lost next year. So careful planning will ensure that hopefully you don't then face issues early next year, and particularly if, when we come to looking at sponsorship and whatnot, there is a bit of a backlog with applications, you end up with a bit of a bottleneck and not being able to get people potentially from next year. So, as I said, you can't ask employees if they've applied, but you can remind them to apply. I'm going to just quickly run through what's called the intra-company transfer scheme. So from the 1st of January 2021, workers coming into the UK using this route will need to be sponsored by a Home Office licensed sponsor. Lots of people do already have a license to bring people in internationally. They must, however, have 12 months experience working for a business overseas linked by ownership to the UK business that they're going to work for. And eligible roles must be at graduate level or above and paid at least £41,500 or the going rate for the job, whichever is higher. So this route is obviously only for particular roles, given the salary and the graduate level eligibility, but it is an option if you have people working in the EU who do satisfy those criteria as an alternative to the new immigration scheme that will be coming in. Licensed sponsorship then, so I've just mentioned that. So from the 1st of January, organisations need to register as a licensed sponsor to hire or continue hiring eligible EU workers on a Tier 2 visa. Now, Tier 2 visa is the general visa, and there are lots of different tiers. Anybody who does regularly use the immigration system will know there are lots of different tiers, but this is the general one that most people will come in on, or, as I said, the intra-company transfer visa. So the rules stipulate that job offers must still meet specified minimum skill and salary thresholds. So RQF3, as it's known, which is an equivalent to an A level, needs to be the minimum skill level. And either £25,600 needs to be the salary or the going rate for the job if it's higher than the £25,600. Now, there is a UK shortage occupation list that should be referred to when consideration is going to be given to sponsoring non-UK employees. The applicants also need to meet English language requirements. So in many ways, if you've been employing individuals from outside of the EU, much of this is not going to be any different to you. You're just now going to be applying it to your EU employees. Now, the new points-based system has faced some criticism from several quarters, including immigration rights groups and UK business leaders who do believe the system is going to make it more difficult to hire the staff that they need, particularly because there's no kind of so-called low-skilled immigration route in place, which in the UK we do have quite a reliance on. I'm going to go through that in a little bit more detail shortly. So larger organisations whose workforces are made up of a high percentage of migrant workers have got a tough task ahead, effectively, not helped by timeframes of up to 6 months to obtain a licence. And if you want to employ Europeans in the future, getting the ball rolling as quickly as possible is what you need to do. So, as I said, while the current system's in place, EU citizens can enter the UK with their EU passport or ID card and begin of work. As of January, that won't be possible. Now, I just mentioned looking at kind of the mix of the skills mix in the UK. So according to, this is the Migration Observatory back in 2018, 21% of low skilled factory and construction jobs were held by EU-born workers. as were 17% of factory and machine operators jobs and 13% of jobs in food preparation and other skilled trades. So those are areas that potentially are really going to struggle in terms of filling those gaps with UK workers. And again, just looking at this qualifications and skills mix, as I mentioned already around the transferable qualifications, what the information tells us is that people from older EU member states tend to be more concentrated in education, professional and scientific sectors, while workers from newer EU member states tend to be more concentrated in retail, transport and storage. And in 2018, more than half of workers from newer EU member states were actually overqualified for the work that they did, compared to less than a quarter from older member states. So again, that tells you the skills mixes that we may retain, and potentially skills mixes that we could lose also. Have a quick look at the new immigration point system. Anybody again who brings people in from outside the EU will already be aware of the kind of the general principles of an immigration point system. So in this system, all new migrant workers that you employ must hold 70 points according to the new system. So they accrue these points using certain criteria, which includes having a formal offer from you as the employer, 20 points, having the required skill set for the job, which I've said previously needs to be equivalent to A-level, 20 points, speaking English to an intermediate standard, 10 points. But in most cases, the job must also pay a going rate of at least the £25,600, another 10 points. And that reflects then that it's a skilled position. As I said already, there are opportunities for migrants to fill unskilled jobs if they're on a government list of specific shortage occupations, which include nursing, civil engineering, and somewhat bizarrely, classical ballet dancing, for which the minimum going rate salary is the 20,480. So there is an opportunity to gain some lower skilled jobs, but as you can see, they need to be on the list, and the salary still needs to be at least that annual salary per annum. So from January, all jobs are going to be given a standard occupational classification code and a designated skill level. And if you go to the government's immigration rules, you can have a look and see the full list of occupations that meet the criteria are listed in there already. So if you want to have a look and see if the ones that you may bring in more regularly are already in there, then go ahead and have a look at that. So while skilled workers include in trades such as carpenters, plasterers, and they might exclude hospitality jobs, farm workers, and despite the fact that millions of us clap for them every evening through the summer, a large number of lower paid jobs in the NHS and social services, social care. So even if these jobs are classed as specific shortage occupations, and actually most of those are not, many of their going rate salaries are not going to be high enough that migrant workers are going to be able to qualify. So this is going to present a huge headache and staff shortages in many industries, not least the care sector, where 1 in 6 of the UK workforce currently comes from overseas. Okay, let's have a very quick look at costs of application fees, just in case anybody hasn't looked at this already. So this is about looking at the cost of a sponsorship license, you've got visas, you've got immigration health surcharge, immigration skills charge, and potentially, of course, additional right to work checks charges as well. So you've got, this is looking at a kind of a typical tier 2 visa, and this is for a single applicant with no dependents. So you can see the application fee is £464. You've got a certificate of sponsorship fee, as I said, the immigration health surcharge fee, the immigration skills charge and priority processing fee. So for this 3-year sponsorship, it's going to cost you up to £5,750. So certainly something to be thinking about in the overall picture. A quick look at right to work checks, just because this obviously is going to be something people are going to be now looking at. Things are going to be changing, so we need to make sure that we're doing what we should be doing. So they're not going to change until the 30th of June 2021. So you can still use passport and ID cards, and you're not going to be required to tell the difference between EU staff who are already in the UK who've not yet applied to the settlement scheme and new arrivals after the transition. And you're not required to ask to tell the difference, basically to guess who may be in which camp. So the Home Office has also said that employers are not going to be required to undertake retrospective checks on existing employees. So in the event of the deal, then, as I said, those who are already in the UK and haven't applied to the settlement scheme yet, and new arrivals after the transition, you're not going to have to tell the difference. However, it's a little bit grey. This is one of those grey areas I was talking about, how you should undertake right to work checks from the 1st of January and before the 30th of June. Because if there's a possibility that somebody has come into the UK after the 1st of January, then technically they should be coming in under the new scheme. So you as an employer, though, you could potentially be fined if you did bring them in knowing that they had come in after the 1st of January, but technically you're not supposed to be checking almost just the ones that you think might have come in. So what I've found out is lots of people are saying in different forums, obviously legal forums or whatnot, not just general chat forums, that you do need to be careful not to discriminate against those who may have settled status or might be applying for settled status. So in order to be consistent across the board, you just need to make sure that you're asking every individual the same questions. So if you ask everybody for a passport as proof of ID, for example, then you're not discriminating against any one group over others. And you can ask people, and again, you'd have to ask everybody when they entered the UK. So lots of cases already coming out, I've seen, where people have applying for jobs that start in January, and then they've said something to their employer, such as, "Oh, really excited to be coming to the UK. I'm going to be spending Christmas with my family, and I'm going to be travelling on the 4th of January, for example. So if you find yourself in that situation, you know that worker hasn't entered the UK prior to the 31st of December, and technically they should be coming in through the new scheme. If that was to be discovered, that's potentially something that you could end up being fined for. So you just need to it's going to be a bit of a difficult period for the first 6 months. But as I said, if you apply the same principles to everybody, checking passports, asking people when they enter the UK, then and then you following your usual right to work check process, then you should be covering yourselves. Now, I'm going to have a quick look at travelling for work. So if you travel for work into the EU for the 1st of January next year, you might need to just consider the following. So business travel includes activities like travelling to meetings and conferences, providing services, and even touring with art or music, entertainment. So you need to have a look at the entry requirements. As I said, all countries have different requirements, largely similar to what we have in the UK, but you do need to double check that you are going to be able to satisfy the entry requirements, and you may be asked to show that you've got certain documentation. So plan ahead, plenty of time to check. So professional qualifications, as I said, if you are required to demonstrate you've got qualifications, you need to check that they are going to be recognised in the EU. particularly if you're a solicitor, for example, or a doctor, maybe going over on a consultancy basis. You need to double check that your qualifications are going to be recognised. Earning money in the EU. If you're going to earn money in the EU, you might need to tell HMRC about it. You might need to double check whether you've got to pay social security contributions in the country that you're working in. So it's just checking all of these things out in plenty of time. And insurance, you need to check that whether you need indemnity insurance for your employees. So previously, when we were in the EU, lots of policies may well cover travel into the EU, but once we're no longer in the EU, you may need to double check your indemnity insurance to check that you are definitely covered from the 1st of January. And taking goods into the EU, because trade and different arrangements are going to be changing, you need to double check that you've got the right documentation from the 1st of January to take any goods into the UK. Okay, hopefully that's all the bits and bobs on immigration and going into the EU. So we're going to have a quick look at contingency planning, skills, profiling. So in the immediate aftermath of Brexit, as we've already shown, there may well be skill shortages across various industries, and organisations urgently need to assess whether they've got the skilled labour that they need within their workforce, where they might have previously sourced skill shortages from the EU fairly easily. This isn't obviously going to any longer be possible. So the most obvious sectors using skilled staff in the EU, as we said, are hospitality, construction, healthcare. And lower skilled roles may become difficult to fill. As we know, it's talked about in general terms, there's a feeling that there's a distinct disinterest from UK nationals in filling certain roles in sectors in hospitality and farming, for example. And UK nationals might actually demand higher wages than the EU counterparts did, pricing out some businesses from hiring as many people as they previously might have been able to. So for businesses looking for lower skilled labour, recruitment might be tougher. Labourers, office administrators, hospitality workers, other non-degree level roles obviously are going to be barred from sponsorship. So you might want to look at your current labour workforce and assess whether you might have skills gaps and start looking at how you can fill any skills gaps. So you need to increase your awareness about whether you're going to be able to continue to retain your current staff, because some of those might be able to get jobs elsewhere, because the competition for those roles might increase. So you're going to have to look at retaining staff in a different way as much as you will around recruiting staff, and where necessary, still transferring staff from the EU, because obviously there is still going to be a requirement for that. So roles that can still be sponsored might have increased salary requirements or salary costs for you to consider because of those immigration fees that I've already gone through with you, which, to be honest with you, is going to price some businesses out of hiring from outside the UK. So step one is assessing your future resourcing needs. So it's having a look at the performance of employees in order to identify the skills gaps. So this involves gathering data in order to determine competency gaps and find root causes that need addressing. So this process is the sort of thing that you would normally do anyway when you're looking at training needs for staff. You're just looking at it through a slightly different lens, basically. So ways of identifying skills gaps include looking at key performance indicators. Are there areas where targets are not being met? Undertaking employee assessments or a skills audit. So surveying your staff about the skills that they have that might not be related to your current role. Some organisations actually do this really well and they do it anyway. It's actually really good practice to know that some staff who might have been brought in to do a completely different job, you didn't realise that they might have transferable skills and you could actually move them potentially to another role. And you could conduct a 360-degree review. Not sure if many of you undertake those already. So this is where managers and peers might actually identify skills that an individual might have that are transferable, that could be utilised in another role, or with a bit of training, potentially move to another area altogether in the business. So when you're looking at conducting your skills audit, you want to be having a look at previous work experience, qualifications, training, technical skills, specialist knowledge, competencies or transferable skills, potentially leadership skills if you're thinking you might move somebody into a supervisory or management role, and even personal development interests. So areas that people themselves have identified an interest in moving into. And step 2, you want to look at weighing up the pros and cons of employing overseas skilled workers against your potential alternatives. So reviewing the data that you've collated, identify the gaps in your skills requirements, particularly if you all are getting this from employees in the EU. And it might obviously be less cost effective to do that in the future, or even just more difficult because of the skills requirements or the salary or just the process itself. Then consider if any of these might be a suitable alternative. And bear in mind that some of them might require a longer term investment, but that doesn't mean that you shouldn't necessarily consider them at least. So automation. Investing in technology to do some aspects or all aspects of a role. I'm seeing lots more of this than I perhaps ever thought I would these days in areas that I hadn't necessarily expected to. So people really starting to think about looking at different processes and how they can automate things and just change people's roles effectively. Redeployment. So consider moving staff into different roles. If you are going to do that, again, you're going to have to make sure that you consult with them because it is classed as a contract variation. But again, if you do it as part of looking at their own development, areas that they're interested in moving, then potentially it can be a mutually agreed move anyway. Raising skills investment. So put together a training programme or to hopefully then to reduce employee turnover, demonstrate value. Because through training, individuals with different specific skill sets that you're currently buying in from elsewhere, you're going to potentially retain people and you're increasing the skill set that you've already got in the organisation. Have a look at apprenticeships. They can be a really cost-effective way of bringing in new skills and ideas to the business. So by bringing in an apprenticeship doesn't mean you necessarily have to bring in a new person. You could potentially train one of your existing employees in an apprenticeship. So you could bring them in and you could train them. And again, as a way of keeping them in the business because they can see a path to development, improving job quality. So if you want to retain staff, you might want to review the job itself and consider if it can be improved so that you individuals may stay longer in the role. If it's an area where you do have a lot of turnover and at the moment you're relying on a glut of low skilled workers that can come in and do the job until they get bored. And improving the brand of your organisation or the role itself. So consider spending money on becoming an employer of choice. So either through increasing your terms and conditions offer or even an advertising campaign so that people will want to work for your company. So they see you, they see that you're a visible organisation, makes you potentially a bit more attractive. And develop a closer working relationship potentially with local colleges and schools so you can encourage individuals to join you and to train as they work and potentially even delivering accredited training through an organisation and your workplace, developing something between you. As I've already said, I've mentioned actually raising wages and improving conditions, so retaining more staff that way, or even outsourcing. So some of the areas where you rely on EU staff now, consider whether, because it's going to be more expensive to do that in the future, you can actually outsource the functions that you currently rely on EU staff for, and it might actually become more cost effective to no longer do some of that in-house, but to just outsource the work to another company. And step 3, So put together a plan of action, assess the most cost-effective way to fill the gaps that you might have, considering all the options that I've just been through with you. I said to you, I'm going to mention some key employment policies and procedures. One of the main things in HR, I think we thought when we first realised Brexit was something that was a reality and it was going to happen, was just how much employment law is likely to change. And the one thing that quite quickly emerged was that's not going to be the case. It's not going to be lots of radical employment law changes in the short term. There may be some longer term. I think it's fair to say that the lack of certainty about Brexit and the impact on EU nationals has caused huge anxiety. And now that a clearer way forward is emerging, you can finally start to implement some of your Brexit plans and provide support to staff. And although there's no legal requirement to provide information around the immigration and whatnot, staff you've already got employed, but lots of organisations have been putting together little Brexit packs for staff. And we're going to go through some different areas of communication you might want to have a think about engaging staff, and just to see if any of them are concerned and dealing with the problems before they become bigger problems. So you might assume that your EU national employees already know about their legal position and the details of the settlement scheme, but some may not. So if you can provide reassurance to them there's no risk with their right to stay and work in the UK, as long as they make their application in time, obviously, then they might be more reassured to hear that from you. As I said, although much UK employment law is derived from EU law, the UK's withdrawal from the EU is unlikely to have an immediate effect on employment law. Following the UK's exit from the EU law continues to apply during the transition period that's now in place. When the transition period ends, existing EU law will actually be converted into domestic law. So most EU directives are actually already implemented in the UK by UK regulations or acts of Parliament. So, for example, the EU Equality directives are implemented by the Equality Act, and it'll be for Parliament to decide whether to retain, amend or repeal the domestic legislation. Commenters have, I've seen lots around this, identified that the harmonisation of contracts after a TUPE transfer is something that may be tackled, something that's not completely accepted, although it has to be, of course, in the UK. Calculation of holiday pay may change over time, agency workers' rights, and even potentially the introduction of a cap on compensation and discrimination claims, because these are areas where the EU tells us what needs to happen, and some elements of that are non-negotiable. But so in the future, there may be some of that may be rolled back. So the UK are not going to be bound by decisions made at the ECJ after the 31st of December. They will be, however, up until that point, bound by case law. And until the UK starts making its own case law, then some of that case law will continue to apply. And in terms of specific policy change, as I said, there shouldn't be much to change in the short term, with the exception of any policies related to immigration, right to work checks in recruitment or travel in the EU, for example. So for immigration, obviously you need to outline what the company policy is on recruiting individuals from outside the UK from the 1st of January 2021. And for right to work checks, asking when an individual first came into the UK as part of the recruitment process, and ensuring that the right to work checks are completed in advance of a formal offer of employment being made. So this is something that if you do hit a problem, so some people only do right to work checks on people for their first day, and they may do something tentatively at the recruitment process, and then when they start, they bring in their paperwork. If you hit a problem on that day, then obviously that's going to cause you a big problem. So you need to be looking at your process and making the formal offer much earlier and seeing that documentation much earlier as well. So if you're travelling in the EU, you've got to check you're free to travel in the country, in the country without a visa, or outline what the visa rules are in the company. And I said you might need to make reference to the form HMRC, checking liability insurances, and also documentation if you're taking goods in. Data protection. So there may need to be some adjustments to data protection policies to show where data is shared outside of the UK. Because previously, if data was shared within the EU, that was identified. Now it will need to be only within the UK and clearly identified if it's being shared outside of the UK. And in employment contracts, if you've got international contracts of employment, you need to ensure that these are reviewed and legally compliant from the 1st of January. I said about communication. So you're going to need to develop a clear stakeholder engagement plan that covers employees and other stakeholders. That might be the board or shareholders if you have those, customers potentially. So the thing to do is to make sure you're having frequent and regular communication, tailored for each audience. Ensure that communications are updated regularly as any messages or priorities evolve, and depending on how the UK's exit strategy continues to unfold. Nominate a key point of contact in your organisation for staff to raise concerns or questions, because they might even think of something you hadn't thought of. And consider putting together a staff forum, a group of nominated individuals from different sections to talk about the impact of Brexit and discuss ideas about how to reduce negative impact. And maybe even put together a frequently asked questions document that can be shared with everybody as and when they might need it. So I'm going to have a quick run through some opportunities to help the business grow. So the dust will settle. Whatever happens with Brexit, the first 3 months might be a bit confusing and take a bit of adjusting to, but after that, we're going to have a much clearer idea of how things are working. So as the clock strikes on Friday the 31st of January, the UK will cease to be, as the clock strikes, no, that was as the clock struck, sorry, on the 31st of January. We're technically ceased to be a member of the European Union. So much of the talk in relation to post-Brexit is to do with safeguarding and how we can mitigate disruption. But as I said, we can do better than that. We can have a look. By exiting the EU trading bloc, the UK is going to be free to strike its own trade deals with other non-EU countries. So as an EU member state, this wouldn't be the case. So all EU member states play by the same rules. And in principle, now the UK could strike a deal with the US that removes trade barriers from importers and exporters either side of the Atlantic. There will be less regulation, particularly for smaller organisations. There's a lot has always been made of kind of the red tape, the regulatory burden that being in the EU has imposed on businesses. So going forward, the UK will be free to set its own regulations and standards. And for some smaller businesses, that might mean them saving money and being able to get products to market much more quickly. So domestic trade, as a result of weakened pound since Brexit in 2016, imports have actually become more expensive for UK businesses and consumers, which obviously has a knock-on effect on production. So we've seen price rises in supermarkets, for example, on lots of branded goods. And a no-deal outcome would actually lead to further price fluctuation. But the increased cost of doing business with the EU may make partnering with UK suppliers more attractive. So domestic products which were outpriced previously by EU imports might be positioned more competitively post-Brexit. And for many businesses looking from the workforce perspective in retail, hospitality and construction, they're reliant on EU workers. So there's an opportunity to offer training or work in people in the recruitment sector to play a key role in equipping businesses in the post-Brexit job market, because lots of organisations are potentially going to be relying now on recruitment organisations to bring in their EU workers going forward. I'm just going to mention automation again. just to say, again, this could potentially be an area where you might be able to, it might be a new opportunity for you. Have a look at what you do now and whether you might be able to automate some of what you do. And it doesn't necessarily mean taking jobs away from human workers and giving them to machines. In a lot of cases, actually just improves what employees do by helping them to streamline processes, and particularly where they're freed up from more menial, repetitive tasks, like scheduling appointments, for example. They might have time to focus on tasks that more directly benefit the business. Therefore, use the Brexit as an excuse to review your processes and see where you might have an opportunity to automate and improve processes. And Brexit could be an opportunity to pick up business from companies that have left the UK. Take the fishing industry, like UK fishing industry. If EU countries lose the right to fish in British waters, then that could give UK fleets a much fairer share of fishing rights, although we know that's a hotly contested area of discussion. And Brexit might cause homegrown support for British businesses. So more people in the UK are likely to say, we want to shop local. We've seen a lot of that this year. We want to shop in the UK. So it's as I said, people have done it anyway. Lots more people are looking at people being ethical. And this could be another one of those opportunities to attract, make sure that you're shouting out about the fact that you're a UK-based business, because that is something that people are looking for at the current time. And potentially look at diversification. So can you create multiple streams of income by bringing in different aspects to your business? If you're reliant on one market or one big customer or one major supplier, you're much more vulnerable. So looking at where you might be able to develop new products or services, expand into new regions, target new customer segments, or expand your professional network may well make your business much more viable. And small businesses are a big advantage here, because they can usually innovate and adapt and respond to market changes much more quickly than bigger organizations. So this can be these can be really good opportunities for you as a business. As I outlined earlier, if you've got a clear communication strategy, a nominated point of contact for employees, then you can even utilize the forum to discuss potential different diversification ideas. Okay, so we're coming to the end of the webinar now. So just a little action plan for you based on what we've covered today. So make sure that you understand the developing rules on immigration and right to work checks after December 2020 as it impacts on your business. Undertake a skills assessment process, weigh up the gaps and alternatives available to you. Review and update any employment policies that we've talked about, and develop a communication plan. And then finally, consider and seize any new opportunities. Okay, so I'm going to switch my camera back on, if I can find the right bit. There we are, to give you an opportunity to ask questions. So Lisa, I don't know if we've had any come through in the chat so far, have we?
Thanks, Lesley. No, I've got no questions on the side at the moment. If anybody wants to come off their mic, and then there's a lot of information given in that one there. And obviously we can send the slides out as soon as we get the AG3s back if anybody requires them. But is anybody out there that would like to ask Lesley a question while she's here?
Yeah, I have a question. It's Lynn. Talking about the right to work checks. Hi, Lesley. Thank you. I've just taken on an employer who isn't starting until January the 4th. And literally, as we have been on this webinar, an email has come through regarding, because we've taken us through a recruitment agency. She is Italian and going home for Christmas. Therefore, I don't know now whether she is a UK citizen or not. And really, because it's quite ambiguous about the right to work checks, what do I need to do precisely?
I would suggest that you just do what you would normally do and don't do anything different, because if if you think she's going home for Christmas, and that suggests she's already here, yes, and not that she's necessarily...
She's just confirmed she is going home for Christmas.
Yeah. So I would suggest you just do the checks that you would normally do, unless she in some way indicates that she's, you know, coming on the 4th of January is going to be the first time that she's actually you know, working, staying in the UK, then that might be slightly different. But it sounds to me like she's already here, she's going home and coming back again, so you don't need to worry.
Yeah. Okay, lovely. Thank you. Appreciate that.
No problem. Sorry to worry you about that.
No, it's a minefield now, isn't it? It opens up so many changes, and we're all fully aware that HR can change on a day-by-day basis, and of course with Brexit that can change as well. So
yeah, exactly. So as long as you do what you're doing, you document what you're doing, and again, your justification, you can always say, you know, I attended a webinar and this was kind of what was covered. Again, that's what, if you were to be reviewed at any point over the decision, then it's just about having that information to show that the decision that you were basically, you know, making your decision on. But it's people who are ignoring the rules that are, you know, much more likely to get fined in these sorts of areas. And I think, if I'm honest with you, then anyway, there's going to be a little bit of leeway, I would expect, unless people are blatantly ignoring the rules anyway.
Yeah, okay, lovely. Thank you very much.
Thanks, Lynn. Anyone else like to ask Lesley a question this morning? No. I think you've covered most of everything there. And obviously, like I said, we can send those slides out. Can I just check anybody who's on here? I meant to say at the beginning as well. If you're from the same companies but sharing the screens or whatever that you're logging in on, can you just let me know so I know that I'm getting all the forms out to everybody there? That would be fab. Just pop it in the chat facility there for me. So thanks, Lesley, for giving your time up this morning again. Some of you I'll see on Wednesday, and some I'll see on Friday at our skills masterclass, I think, webinar there. So thanks everyone for giving your time up this morning, and we'll see you soon. Thanks, Lesley. Thank you.
You.
Bye. Bye.
Bye.